Yes, welcome to the No State Project, live from the fortified compound in Mesa, Arizona. Glad to be with you here. It is December 1st, 2018. We are 11/12 of the way through the 2018, and glad to be with you here. Good to be back live on the Liberty Radio Network and streaming live, of course, on my YouTube channel. So, because you have no excuses, you can hear the live broadcast anywhere, either from the LRN stream or from my YouTube stream. So I want to thank for the continued support of the show, Brent, Bill in New Hampshire, Dan, Nelson, and Dennis for this week, helping to bring, sponsor the show. Well, or support the show. Don't like to say sponsor, but just support. I do appreciate that. If you'd like to help support the show, it is always welcome. Just go to markstevens.net and you're able to do that. But I do appreciate everybody who does help support the show. And Eyal, of course, in Israel, who's been a regular on the big broadcast. If you would like to be on, I don't know what the hell's going on today. If you would like to be on the big show, you may do so. We're talking about anarchy, getting to a voluntary society, government abuse, which could do the whole show on that. Let's see, do we gotta, maybe, yeah, there we go. Maybe take that. Yay! Government abuse, which I'm going to do some reporting on that. And then defending yourself in court. We had a good session on the Wednesday commercial-free broadcast, getting back to the basics. So somebody who had called who was very new to the material. Who was that? I think it was Chris in North Carolina. So I did a lot of talking about the very basics, getting started in defending yourself. But if you want to join me on the show to talk about these topics, it's 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign, and it's not a toll-free call. But if you want to join me on Skype, Insta message me first. I'll actually open up the Skype program as we speak. And Insta message me at Frank Rizzo 3. It's the number 3. Frank Rizzo 3. And I will bring you up on a break. So this is a commercial radio broadcast I stream here on my YouTube channel, so we get more people that can actually call into the show, listen to the show. So on every quarter of the hour, yes, we are going to have commercials. So what I'm going to do is, like usual, I will pull this live stream down. I know you'll miss the Iron Maiden shirt, but it'll be a better quality audio and no commercials. So that's how we do that. And yes, it will be available today. Should be available today at markstevens.net, which of course you can get Government Indicted, which has a whole model that is proven to be effective at defending ourselves in court, whether it's the United States, Canada, Australia, or England, and basically keeping the burden of proof on the accuser where it belongs. And one thing that I want to talk about, gosh, It is wow, what a news cycle. Now again, I'm very distrustful of this criminal organization we call government, and very skeptical, of course, of media, any media. However, because we look at the orchestration of the war in Afghanistan and Iraq, and we know that there was complicity with the media. Most of the media in the United States, to foster this lie of weapons of mass destruction and other abuses by the Bush administration, and how the war in Afghanistan is the longest war in American history. It's over 17 years now, all on lies, all on demonstrable lies. And we know the media was complicit. There's no doubt. They had those stupid warnings. It was, some people just grew up with that, with the terrorism risk, the color code thing there. Thanks, Tom Ridge. So we know that the media have been complicit in these government lies. We know that the media has put out propaganda pieces, especially with the Bush administration, where they were running things as news, and they were produced by the Pentagon and by other government agencies and ran as news. So I get that, but you have to keep we have to keep in mind, not everything that they're saying is a lie, and that's what makes it a little more insidious. So you have to look at multiple sources. And again, if a politician told me the time, I would have to verify it. But is everything a politician saying a lie? I don't think so. I think there's a lot of half-truths. I think there's some outright lies, but not everything in the media is a lie. Not everything politicians say is a lie. So you have to use some critical analysis and look for more sources. Okay, the more sources, usually the better. So one interesting thing that came out, and I spoke about this last week. I mentioned, and yes, I got the name this time, Amber Guyger. So if you look at the title to today's show, she was actually indicted. So it's been reported on multiple, and this is something I guess you can always go into the Dallas. You can look at the docket and you can actually get the indictment. Some things like that are public, but it's and I'm reading from abcnews.com. The former Dallas police officer Amber Guyger indicted on murder charge for killing man in wrong apartment. Now, this is, again, it's extremely rare that a police officer has been indicted. But now, yes, they can go for a lesser charge of manslaughter, which is what she was charged with initially. And here's your blue privilege. 3 days after the murder, she was indicted. Not indicted. She was charged with manslaughter and held on a bail. It's interesting when you hear from her lawyer, Robert Rogers. He released a statement late yesterday. He says, "I'm not surprised that a grand jury came out with an indictment. There's an outpouring of vindictive emotion that's been building up." You see why people don't like lawyers? You have to go based on the facts. You have to know the facts. And, of course, here we're going by the facts that were reported. She changed her story. So his own client, being that she changed the story, is really not a credible source. I don't think so. Vindictive emotion, she went to the wrong apartment. There is no dispute to the fact that she was in the wrong apartment. She said she was in the wrong apartment. She obviously was in the wrong apartment. There's no disputing that. She killed a man. These are the facts. She went to a different apartment. She claims she went to the wrong apartment. She shot the man who lived there. Now, if that was you, if it was me, you'd be arrested on sight. You don't get 3 days to make up a story. You go and you're going to jail that day. So it's going to be one of those days. So that is, of course, some of the privilege, the blue privilege, or the privilege of being one of the king's men, that you can murder somebody and go home. That doesn't happen to the little people. But we're up against a break. I just heard that we'll continue this and more on the other side. I will connect to the call line. And again, if you want to join me, it's 218-632-9399. The passcode is 2020 with that there pound sign. And we'll be back in just a moment, so don't go away. Yes, welcome back to the No State Project here on LRN.FM and the Liberty Radio Network, and streaming live on my No State Project YouTube channel. And somebody's mentioning here, the statism is a cult. I think when you've got, when a cult gets to a point where there are billions of people that are a part of it, I think you've you've gone way past the line over religion. So I don't think it's necessarily accurate to call it a cult, but it certainly falls within religious parameters. That's for damn sure. It is certainly the most dangerous religion. That is statism. So it has all the so once a cult gets large enough that there's mass acceptance, I don't think it's appropriate to call it a cult anymore. But what I was talking about over here is Amber Guyger, Dallas police officer, has been indicted on murder charges, and her attorney is saying that there was a lot of political pressure that seemed to play a role in how the DA handled this. Wow. She went to the wrong apartment. And killed the man who lived there. Then they tried to smear him. Why would they need a warrant to search a crime scene? That doesn't. I'm missing something there. But they tried to smear the victim. I think the facts were, if there is emotion that's injected because people are tired of cops getting away with killing people. I'm not even being charged with negligence. So you just keep going back. Dick Cheney shot a man in the face and wasn't even charged with gross negligence. Nothing. The people, if there's emotion, it's because we're tired of being killed and beaten and harassed, and that there's almost never anything done about it. But here the facts speak really clear. You go to the wrong apartment, you shoot the guy who's in there, at the very least, you're doing some time for something. But see, the rules don't apply to us. He says, I don't know what happened in the grand jury. Well, maybe the prosecutor actually just presented the damn facts and the statements of 300 witnesses that were taken. But I do believe emotion was injected into this that might have led the grand jury astray from just focusing on the law and the evidence. No, you walk into you pound on the door of someone's home. You change your friggin' story after you kill him. See, that's the thing. If you change your story after killing somebody, lying to the police is a separate crime. Not only do you have lying to the police, but you have obstruction, which is typically a felony or a very high-level misdemeanor. So I think here this lawyer, Robert Rogers, see, lawyer's job is to punch holes in the actual evidence and the arguments that the prosecution's using, not to just do. This is not a good defense. Is it all based on political pressure? You're not showing where the facts are wrong. You're not showing where the evidence is wrong. That she went to the wrong apartment, lied about doing so, and then killed the man that was in there. And there's no evidence of any kind of self-defense. He says this case hasn't been tried in a fair forum yet. I'll grant you that. For the most part, grand jury is secretive, but when we get a fair forum in front of 12 dispassionate citizens, I believe the law and evidence will show Amber Guyger is innocent. Well, see, that's the thing is, not only is it unbelievably rare for a police officer to even be charged with killing somebody, whether it's a murder or manslaughter, negligence, or something like that, to actually get them convicted is even more rare. So again, I'll go back to Michael Slager was this South Carolina? North Carolina. North Charleston, South Carolina. Killed Walter Scott. It's on video. He not only killed an unarmed man running away, the video shows he's getting shot in the back. The forensics, of course, back that up. Like it wouldn't. He is on film planting evidence and falsified the record, falsified a report, a felony connected to a murder. The people covering up, that's called capital murder when you try to cover it up. He was acquitted. There was a mistrial. One juror held out. One juror triggered a mistrial. So I think there was 2 mistrials, and then it wasn't until the feds came in that Michael Slager pleaded guilty to avoid another trial, and is getting 20 years. So it's extremely rare. There's another case here that where a police officer was acquitted. Also, I guess I lost my place here. Tenzing. Yeah, there was an officer, Tenzing, who was also acquitted. Ray Tenzing shot Samuel Dubois. He shot him in the head during a traffic stop. The killing is also on video. The prosecutor said it's the most asinine act I've ever seen a police officer make. People want to believe that Mr. Dubois had done something violent towards the officer. He did not. He did not at all, and I feel sorry for his family and what they lost, and I feel sorry for the community. Purposeful killing of another, that's what makes it murder. He purposely killed him, and they had video of that. And even though he was put on trial, there was a mistrial or he's acquitted. I don't see that he was, but he wasn't convicted. So it's great that they've taken this step, this drastic step of holding one of the king's men to some accountability for murdering somebody. I mean, you look, if you have a little bit of marijuana, you can go to jail for a decade. And it happens all the time. Don't have any money if you get charged with a traffic offense, okay, and you go to jail. These cops kill people. They kill people. Even if it was an accident, if it was negligence, that wasn't their intent. Why should they get away with killing people when you and I can't get away without having a driver's license? Don't tell me that there's not a ruling class. Don't tell me that there aren't 2 systems of justice, because the evidence doesn't bear that out at all. So I'm starting to think that anyway. All right. Well, we're up against the break. I'm glad I can actually hear the feed this time. We'll be back with your calls. The number is 218-632-9399. The passcode is 2020. We'll be back in just a few moments, so don't go anywhere. Yes, welcome back to the No Stay Project here on LRN.FM, the Liberty Radio Network. And streaming live, of course, on my YouTube channel, which is, of course, No Stay Project. So I'm glad to be with you here from the fortified compound in Mesa, Arizona. If you want to join the big show, 218-632-9399. 218-632-9399. The passcode is 2020 with the £. So that's what we do if you want to join the show. It's not a toll-free call. So anyway, if you're concerned about that, then you can instant message me on Skype at Frank Rizzo 3, Frank Rizzo with the number 3, and I will connect you on a break. So, okay, so let's get through the damn calls here. We have, it looks like Marva that's what I wrote anyway, from Georgia.
Hey, Mark, how are you doing?
I'm doing well.
Long time no talk.
Did I get the name right?
Great. Yeah, it's Marva. I have a question regarding what started out as an infraction, traffic matter in North Carolina also. They tagged on the resisting officer charge that would be the only misdemeanor. There's no witness. There's no injured party. I listened to you before, so I followed the suggestion of doing the motion to dismiss, outlining the different things, queried them also on, whether the statutes or law apply to me. And challenge them on standing in jurisdiction. The judge actually said there was no crime in the district court, but he still proceeded. Several times the cop didn't even show up. I moved for dismissal, which that didn't happen. So the judge, one occasion, he finally forced the proceeding, and he found me guilty. I didn't consent to the proceeding, but he forced the proceeding. He found me guilty. This is on a no driver's license, but they are using an old expired North Carolina driver's license, knowing that I have a Georgia driver's license, meaning they've had it in their hand, called the dispatcher, confirmed that it was active and valid. And yet they're proceeding with these charges, which, by the way, they charged me before on the no license, and the judge dismissed it. So he charges me. He tells the clerks that I can't file any more documents. He was trying to prevent me from doing the appeal in writing. I'd given verbal notice of appeal.
Okay. Well, before,
anyway,
wait, Margaret,
so
before you get too far, before you get too far into the narrative, I got some questions here.
Okay.
So the cop doesn't show up. You object and move for a dismissal. The judge refuses. Did he conduct a trial without the police officer there, or did he reset it for another day for when the officer did show up?
He actually waited, like, it was like more than one time that the cop didn't show up. So he finally waited. When the cop showed up on the date that the cop showed up, he forced the proceeding without my consent, without producing any discovery or anything like that.
Okay, well, they don't,
in the district court.
Their proceedings don't require your consent ever. It's not a matter of that, they're trying to contract with you. I hope that's not where you were going with that. These proceedings are all done under threat, duress, and coercion. You either participate or you go to jail, and that's the way it is. And I've dealt with prosecutors and judges who do not like us pointing out the facts, but anybody, anyone who says that participation in a court proceeding is voluntary for someone who's a defendant is lying. They're grossly mistaken. That's not the way the law operates, and that's not how things are in practice. So we never object because it's not based on our consent. So so the judge, over your objection, allows us to go, forces this to trial. Was there a prosecutor assisting? Okay. And
there's an assistant DA prosecutor, which, by the way, a whole nother story, but one of them is the daughter of the Superior Court judge that they brought into Moore County to make a wrongful action on our home place while they were putting me in jail all these times when I would go to court. So I've been falsely imprisoned over this. One day I stood up and said, I'm a woman, Marva. I moved for a continuance. I was held in contempt. I have been assaulted multiple times, even in open court. Okay. So it goes to the Superior Court. A traffic matter goes to Superior Court, infraction. On appeal, it was continued the day of the arraignment. I got in the hallway and I realized they didn't ask for the notice that I was there. And the reason why I wanted it was because this ADA was alleging that I wasn't there. And even though I had admitted documents into the record and had the stamped file, at that time, I asked for it. Well, I was out in the hallway and a bailiff was going back into the courtroom. And so I asked him if he could just get the note for me from the clerk. He comes back out and says that I'm not supposed to be there, that I'm not supposed to be on the premises. He then grabs my arm and he said, I touched you, now I got to take you to jail. So he then begins dragging me away. Eventually takes me across the street to the magistrate. I'm put in jail. By the time he gets over there, he's come up with disorderly conduct, resisting officer, and second-degree trespass. I was there at the court, for court by force, threat, and duress. Do
you have an order from the court that orders you to be at the court at that time?
Yeah.
Wow.
I mean, it was
Oh
on
my
the
gosh.
calendar for me to be at the court, and that was the first day that it was in the Superior Court. So I didn't have anything on writing, but it was on the.
It's on the docket.
I
Well,
was
okay.
ordered.
So
I mean,
you do
based
have it
on
on. It's on the docket, so you can prove that because it's on the docket, you have to be there, or they'll issue a warrant. This reminds me of that movie Beverly Hills Cop. You know, when he gets thrown out of a window and he gets charged with breaking and entering. Holy crap! All right. Well, okay.
It gets worse. It gets worse.
Okay, but
So,
before we go, wait. But Marva, hold on. Let's see what we can do about getting through what happened at trial first. You're telling me this prosecutor put a police officer on a stand and entered into documents to try to prove that you were driving on without a valid license, even though you have a valid.
No, he had no evidence.
So
no, the cop had no evidence at all.
So what did the
created
prosecutor?
A story.
What did the prosecutor use to show that he didn't have a DMV record, at least, to show that you were on a suspended license? Wow.
No, I wasn't on a suspended. Nothing. No evidence at all.
So did the cop did the cop at least testify to that? Did he testify to what he actually charged you with?
He testified. He named this. Well, I don't even know if he stated the statute. What was happening, the judge and the assistant DA were telling the cop what to say. The cop alleged that there was a murder case in Charlotte. I'm going totally opposite direction from Charlotte, so I don't even know what I would have to do with that. So he alleged that I crossed the line and that I had no license. I failed to stop to the blue light. Oh, I was a female traveling alone, and I've been stopped by the police before. So as a safety measure, I called 911, put my flashers on, and I had on I slowed down.
Okay, well, Marva, hold on a second. We're up against the break. I got to mute you up. This is wow. This is horrible. I guess you could take away from this. She's able to call, so it wasn't as bad as you would think. Some of these calls wind up with these psychopaths with badges. My name is Marc Stevens. It's the No State Project here on LRN.FM and streaming live on my YouTube channel. We'll be back with Marva in Georgia in just a moment. Don't go away. Yes, welcome back to the No State Project here on the Liberty Radio Network. Of course, it's LRN.FM and streaming live from my YouTube channel, No State Project. And all traffic, just briefly, all traffic is criminal. Just in the courts, some are treated as civil. So you can go into the Arizona Code and you can read it. That for the ease in prosecution, they treat some of them as civil. I presented evidence, and wow, this got quite a response. When you appeal a civil traffic case in Arizona, for example, once you get to the appellate court, you get a CR number, not a TR, a CR, which is criminal. All traffic is criminal, but some are treated. Some of the lower rated offenses, like no driver's license or not, are treated as civil, but they are in fact criminal. And the courts have ruled, Eric, you go back, 55 to 80 years, you're never going to win on that they need a warrant on the traffic stop as long as there was some initial. I know you would not in probable cause of a crime, but you're never going to prevail in court that I've ever seen that. As long as the police officer had some reasonable, in their eyes, reason to pull you over, whether it was for speeding, whether it was an illegal lane change, then they have probable cause. The courts always uphold a probable cause for the rest of that. That's one of the reasons why they want your window to be lower so that they can lie saying they smell pot. But I want to get back to Marva, who's got some real problems here. Okay, so Marva, so you're telling me, did you object to the police officer being put on the stand? And did you object and say that you hadn't gotten your discovery? Did you make those objections prior to?
Yeah.
Okay, you did. And the judge just blanketed, denied all your objections.
Just railroaded right on through.
So what did the prosecution actually? I didn't say anything. But what did the prosecution offer to support their argument that you had a suspended driver's license?
No evidence at all. It wasn't a suspended. They were alleging I didn't have any driver's license.
Oh.
But that's not true.
I thought they were going okay, because the Georgia. Okay, so did you cross-examine the police officer?
No, I didn't. And the reason that I didn't is because I stated that I didn't consent to the proceedings. So I knew that it wasn't going to make any difference because it was clear they had already made some decision about what they were going to do.
But you need to have, we need to have solid issues for appeal that they're actually going to address. And so you do the cross-examination to bring out that the police, because what'll happen is they won't allow you to cross-examine. And so if the only issue you brought out on appeal, you brought one single issue, you were denied cross-examination, the only witness against you, all you have to do is show that you were denied cross, and that's easy to do. If you couldn't prevail on that on appeal, you got to, now then nothing was going to change. But I would always recommend that when they put on these dog and pony shows, and you don't have to convince me that it's fixed and that they're criminals and that it's not fair. I would still recommend to get as much evidence against them as we can, and one of the best ways to do that, so that we may prevail on appeal, or at least, like I'm going to go into next, or later, we'll talk about an insurance claim, because this is right for an insurance claim, is that we're able to get the judge's own statements and the prosecutor's statements and use that against them to show that they denied you a fair trial because they wouldn't allow you to cross-examine the witness. In fact, that's why we deliberately asked the police officer a question that requires them to give facts to support their claim the laws apply to you. And then that's when the prosecutor goes with the same asinine objection. Objection calls for a legal conclusion. The witness can't testify. When you're not asking him to give a legal conclusion. You're asking him for the facts that his legal opinion of probable cause, for example, was based. And if he doesn't have the facts, or he's not qualified to answer questions regarding why he determined there was probable cause, well, then he's not a competent witness to testify against you. And to stop the cross-examination is unfair and constitutional error of the first magnitude, according to the Supreme Court for the last, 200 years. Wow. So
it's become a very hostile environment. So, like, even with me objecting, I was being told to shut up, not to say anything.
Shut up. So
and like in the Superior Court, okay, so once I went and the Superior Court, that arraignment, it was continued. I'm out in the hallway. The cop then grabs me, takes me to jail, charges me more. Then they started talking about psych eval.
Oh,
so
gosh.
I was trafficked back and forth from jail to the court, like the next day, threatened to be held in contempt by a judge that has falsely imprisoned me before. And so then he assigned a public defender.
Oh.
That public defender wanted me to plead guilty to the charges. So the charges that this new cop has made fraudulently because he assaulted me, and now also the charges that are on appeal from the initial traffic case. So she says that she's not going to go to the DA to ask for a reduction of bond or modification. And so then I'm sent back over to trafficked back over to the jail. The next day or the day after, I was trafficked back over. The Superior Court, the District Court judge, lead judge, was on the bench that day. He's the one who started it, and he said there was no crime. And he, before I went in at the court I talked with the public defender. So she had printed out the different charges, and she wanted me to say that I was guilty to all of them. And she said that her recommendation was going to be for psych eval. And I said, I'm a woman, Marva, and you're a woman, Vicky. Any harm, injury, or damage to me, I'm going to hold you liable, and you are fired. When we went in at the court.
Okay, but before you get into what was said in court, did you give her the facts that you were that you've relayed to me? Probably you probably will give her in a little more detail, of course.
Mm-hmm.
Did you relate to this public offender the facts that you were at court because you were ordered to be there and you were only trying to get verification that you were there because you had previously been falsely imprisoned by a judge claiming you weren't there? Did they know those facts?
Yes.
And they still thought...
Yes, and she was there that day, so she knew. She knew I was there.
She was there and knew?
Yeah. Yes.
Oh,
she knew
my
that I
gosh.
was at court.
You see, there's just like the lawyer, this Robert Rogers, who's representing Amber Guyger. Here we've got a public offender who knows the facts and still doesn't want to lift a damn finger to actually defend you and actually present an argument. You know, it's like one of my favorite movies, A Few Good Men. It was the whole thing. Oh, yeah, he's in law review. He's making an argument. That was supposed to be the whole thing about becoming a lawyer, is to make a valid argument or a valid counter argument to defend your client. And here they know the facts, and yet you got to... What is it with... It seems like 99% of public offenders is just to make a deal. It seems that way even with high-priced attorneys. You pay them all this effing money just to make a deal, just to plead guilty. And I'm like, oh, this is... it's not much I can do as long as the public...
Worse.
It's what?
It gets worse.
Oh, geez. Okay, so, because I want to talk about filing an insurance claim like I would do it this week. And I want to point out before I get into what happened when you go into court with the public offenders. Everybody, if you're going to do the insurance claim, you have to have a statement of facts supporting your claim that go with it. Don't just file a court document or file your appeal. You have to have your own statement of facts to support your claim. So you're saying it gets worse. You and this public defender go into court. How could it get worse?
Public defender. We go in at the court before the head of the district court judge, and I told him that I fired her. He said that I couldn't fire her, and so he proceeded doing the name game. And so he was like, "Well, I'm going to hold you in contempt. Just say the name." And so I just say I'm a woman, Marva. I mean, I just try to keep it simple. I don't want to get into any whatever.
I'm hoping by the name game you're not thinking about the old caps. So hopefully that's not it. That would be a reason why they're doing the psych eval. But just hold on, we're at the top of the hour break. My name's Marc Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. And also streaming live on my YouTube channel, No State Project. We'll be back with the second of 3 hours of Anarchy Radio in just a few moments, so don't go away. We are on a break. Yes, welcome back to the No State Project on the Liberty Radio Network, top of the hour. Second of 3 hours of Anarchy Radio right here on the Liberty Radio Network and streaming live on my YouTube channel. And thanks to Brian again of High Impact Blog, now over 15K on the subs. I wasn't at 9K just a few weeks ago. I was just a few weeks ago, it was about 12.5K. So it's not like, there's been 6,000 subs in just a couple of weeks, which would be sweet. But hey, if you want to know when we're going live, and I'm working on being able to do more live broadcasts, whether it's a regular broadcast like this or role playing, we're talking just about court procedure. So if you get subbed, you'll be able to get a notification for that. I've got to bring back up Marva, who's this is just horrible, and it's one of the things I did a whole video. I think, part of a show. An hour or so where we talk just about what do you do when you're in a situation where the public defender is not looking to defend you. They just want you to make a deal. It's not based on any kind of evidence. They don't want to put any kind of argument in your favor. Not even using that evidence to get a better deal. My gosh. And then the judge is ultimately, of course, the boss in the court. He is in charge of all the lawyers. And he doesn't allow the public defender to withdraw. And they're threatening a psych evaluation. Now, when you're talking about the name game, are you saying you don't want to admit to being the name that's on the paperwork because it's in all capital letters?
Well, because I'm not a fiction. I'm a living person. So, but that's what I mean by that.
Are they charging you as a fiction?
Yes,
How do you know that?
because it is in all caps. It's in all capital letters, and they've done various um, derivatives of the name. Like they've done it Marva Denise. They've done it last name, first name.
What?
So they've done it different ways at this point.
But how does that mean? How does that
Sometimes they do the first and the last name.
But how does that?
The main point to me really is there's no verified claim or no verified complaint. Nobody has come forward and said that I've done wrong.
Yeah, somebody
so
has.
Really
somebody has. The prosecution has done that, and so I can't stress enough this stuff about that they're charging you as a fiction because the name is in all caps. The only support that anybody ever has is going to a, you can't see it in this frame, I guess, it's going to a Black's Law Dictionary, and that's not evidence that that's how they're actually charging you.
I mean, I haven't said that in court at all. I have not said that at all. It became apparent to me, because they were putting so much emphasis on the name. There is something about the name. So I know that they do a bond and all of that, but
there's no evidence of that.
I got it in court. I've just stuck with: is there a verified claim? Who's making the claim against me? If no one comes forward, then I require the matter be discharged.
Okay.
Now
it makes sense.
Stick to trying to get Brady. They've not produced any discovery in Superior Court. They have to, and there are constitutional issues. I have a right to travel.
Well, okay, we're getting into traffic stuff, and if you're making assertions like that, then it's the whole Freeman sovereign kind of thing, or sovereign citizen. Please spare me I'm just going by their terminology. I know it's a contradiction in terms, everybody, but they use the term sovereign citizen, and that is, I'm almost 100% certain is exactly why they are pushing for the psych evaluation, because of stuff like that.
Well, they've labeled me as a sovereign citizen, put an article in the paper on the front page to that effect.
See, but they've got things.
I'm not a sovereign citizen. I don't think you can be. I've never asserted that at all.
But you're going in, and if you do right to travel and stuff like that, those are things put out by sovereigns or sovereign citizens, and they see, if I get labeled that, I can go back and show that there was no. So we did this in Ohio. They came out and the prosecution actually admitted nothing we wrote was something that could be characterized as coming from a sovereign citizen, but it's similar. Well, you can say that anything is similar. You can say that the Chinese Constitution is similar to the United States Constitution. What the hell is that? So you're not. You got a real uphill battle here. You got this for you and everybody else. We have to stick to just attacking their claims that they're actually making. They're actually claiming that the laws apply because you're physically in North Carolina. They'll actually say that. You don't have to make it up or go to Black's Law Dictionary and say, okay, they're actually saying that, and they don't have any evidence or a qualified witness or competent witness to testify to that. And that destroys the relevance and the validity of everything else that they're saying. So you want to stick to that. You can't actually do a motion to you're in a really bad spot here, because you can't file any paperwork on your own behalf. The court's not going to allow it until the public defender is out of there. So maybe the public defender is.
That first public defender, what happened that day, that judge on the district level removed her, but then he sent me up, had the bailiff track me up to the Superior Court where I'd been a day or so prior before Judge Talley, Mary Talley. So she was like, what is she doing here? We already handled that. It was continued. And why is she dressed like that? And so then the public defender began to speak. I said I had fired her, so the judge told me to hush, and heard her. I objected because she doesn't have any firsthand knowledge. She wasn't out in the hallway, so she doesn't know what, apart from my telling her, or what that cop would have said, or she has no firsthand knowledge of what happened out in the hallway.
Well, she's not
At
testifying
any rate,
as a witness at that
the
point.
judge
So
asked her if she wanted to withdraw. She said she did want to withdraw, so she withdrew.
good.
So they continued it. So then, what happened, I've continued to go to court. Like when I've gone to court, it's like I was being put in jail. So then I was back in the Superior Court. The ADA, got a new judge to come in. That judge, she convinced that judge to, have to send me for a psych eval at Daymart. I was actually held in jail 9 days, falsely imprisoned for that. Supposedly for them to take me for the psych eval. Then a notice came about that was signed by the resident Superior Court judge to release me. Apparently that he gave authorization over the phone. I was released. I did go at that appointment. When I got there, they were asking me personal information, date of birth, financial information, and I asked why. And she said because I had to pay for it. And I said, well, oh no, I'm not paying for it. This is court order, whatever. Anyways, they didn't want to say that it was court ordered. They didn't even want to give a notice that I was there. She said they normally don't schedule appointments. They are walk-in, but they only schedule it because somebody from the court called over to tell them to schedule the appointment.
Jeez.
So
Right.
I wrote a notice up myself of that I was there, what was said. I left a copy for them, went and got it notarized, put it in the file. When it came back in court again, the ADA alleged that I didn't go to the appointment. And then she alleged that the people at Daymart said I didn't cooperate. And so then it was a new judge again. And so this new judge, she wanted to get this new judge to hold me in jail and make me go to Butner, which is a state facility. This is totally ridiculous.
Wow, we got to go.
And,
well, hold on, I got to mute you. We're up against the break. We'll finish in the next segment because I got a full boat of calls. So I won't give out the calling number. I'm just to say here as we're going to a break. My gosh, we have got to stop this ridiculous Freeman sovereign citizen type of assertions and whatnot. It's only being used to hurt people. And another psych eval, days in jail. We'll be back with Marva in just a few moments, so don't go away. Yes, welcome back to the No State Project here live from the fortified compound in Mesa, Arizona, and streaming on my YouTube channel, originating from LRN.FM, the Liberty Radio Network. And glad to be with you here on December 1st, 2018. We only got a few more shows left for 2018, and it will be mercifully over. And we can start another year. And it's just been a fire hose of crap. Wow. And I'm going to bring Marva back up. We got a full line of calls, so I'm not going to be giving the number out for the rest of the show. But Marva, let's just try to take this last segment and focus on what we can do to help clean this up and get you out of jeopardy. Have you filed in this other case? Have you filed a motion to dismiss and Brady request?
Yes, I've filed it in all the cases. So,
okay.
This case, I did go to the state facility. They're alleging that it came back incompetent, which is absolutely impossible. I used to do psych evals. I have an undergraduate in psych, and I've worked in that area, so I know that's not the case. So now they assigned another public defender, and they are trying to force me to do another psych eval, supposedly to now say that I'm competent so that I can represent myself. Which that doesn't make any sense to me. And they're paying for it. So the public defender is trying to force me to come to his office to have his psychiatrist do the psych eval on the 7th, which is Friday.
They want to determine whether you are competent to defend yourself or assist in your own defense. And what the hell are they basing that on? What facts are they basing it on that it's in question whether you are competent?
I haven't seen that. They haven't really put any facts on the table to say. I mean, nothing. They've not answered any of the motions that I've presented. No discovery's been provided. They've not answered any interrogatories. Nothing. They haven't answered the Brady.
And they haven't, but the Brady is the big one, in my opinion. Okay. Well, was there a determination on the motion to dismiss?
No, they haven't. They haven't even brought any of the motions forward.
Have you brought this up in court? Again, have you?
I have asked. Yes, I've asked for it to be scheduled and to be heard, and I've stated there are pending motions before the court.
And nothing.
Well, nothing. Now the ADA was saying that she couldn't talk to me or accept any paperwork from me because there's a public defender. So I was just there last week, Thursday, in the district court before the district court judge who started all of this. He's retiring, he said, as of yesterday. And so he was, again, forcing me to go. So I've been stalked by the cop that touched me and put me in jail that day. I've been stalked by him. I was stalked another time. I tried to remove it to the federal court because it was just so hostile. I was literally assaulted in public, in the open court, literally thrown to the floor.
Jeez.
And
there should be video of that.
Thursday when I was there, I was assaulted again. And this just cannot happen. I'm being forced to go there on Monday. The Superior Court is the beginning of the week. And to be quite frankly honest, I don't even want to go there. I acknowledge that I'm learning the law and how to do this, but I've heard so many different things from so many people. I just want to know how to handle things right.
Okay.
Well, I just wanted to go away and I want to go forward with my life.
Okay. But you want to make sure though, but Marc, what you got to do is you have to hold the prosecution to their burden. If they're going to ignore, then there's not much you can do, but you're setting them up for due process violations that hopefully the appellate court will actually address, such as a denial of cross-examination. There's not much you can do while the public defender is there because they're not going to accept any of your paperwork. But what I would do is I would get my facts, put them into a timeline, a chronological timeline of what has happened. And these are county officials that are doing this to you?
Yes.
Okay. I would look up, which county is this happening?
Richmond County, North Carolina, and Rockingham. Rockingham, North Carolina. Richmond County. I
would get a claim form. You can usually get that online. Look for Richmond County Risk Management. And I would get a claim form. And I would attach to it my statement of facts to support my argument or my claim that they are damaging me. And it's being done maliciously, and file that with the county. I would do it, as soon as I have the facts, I had the paperwork ready. I'd get it in this week to do, to hopefully somebody down there might see and I would bring it to the county commissioner's attention, say, you've got judges, prosecutors, and judges out of control. These are the facts. This is what they're doing to me. They have even muzzled me in court by forcing a public defender on me. So I can't file my own paperwork. I cannot make objections. They don't want to make any objections on my behalf. They're not even objecting to a second psych evaluation where there is no evidence whatsoever that I'm not, no evidence of any kind of mental disability whatsoever. And this is going to cause further damage and it puts the county at even more risk than they've already done. So I would let the county commissioners know this is what I'm doing, and maybe give them an opportunity. This is my complaint. This is what's happened so far. These are the facts, and I'm going to file this. This week. I'm giving you a heads up that the county is at risk because of these fellow employees of yours. Maybe you don't want anyone to risk obstruction of justice. You just want a little sanity saying, this is wrong. Or maybe someone saying to the prosecution, did you contest any of the facts that she is filing with this claim against the county? Are any of these facts true? Do these facts really, did XYZ really happen? I mean, you've got a case where you have a driver's license and they're charging you as if you don't. I mean, that's pretty bad. You have.
And here's the thing. So on one of the times when I went to court to take a notice and I came out, there were 3 deputies on the side of the courthouse stalking me. And so they filed the same charges. The ADA, same ADA, she dismissed those charges. So I'm like, how can any other charge stand?
Well, they're giving them the benefit of any kind of doubt. There are different reasons to dismiss, or if it's a different charge, they may be under a different set of facts. I don't know. We'll give them that, but that I would get that going and get in touch with the county commissioners about it. And if you need some help with that, let me know and say, look, these are the facts, and they're up for reasonable dispute. But if taken as true, this entitles me to. This entitles me to significant damages, and I want to try to limit and help and limit the damage to the county because it's protecting me. So I got to let you go, but I do appreciate the call and stay in touch with me. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. We'll be back with Tom from the Big D in just a few moments, so don't go away. And for those on YouTube, we're on a break. Yes, welcome back to the No State Project. I'm Marc Stevens, author of Government Indicted, which you can get at markstevens.net. And one of these things, it's one of them Jordan Maxwell kind of things. Somebody's saying it's not called spelling for no reason. Words are spells magic. And you have to look at the how words originate. It's like people thinking that man and woman have the same, they have the same origin, and they don't. Especially when you're talking about an English word, English is a hodgepodge. So if you look at the etymology of the words man and woman, they have different origins, and it's not just that you took the word man and put a W-O in front of it. Typically, not how language evolves, unless you're talking about very recent, where literally now means the opposite. It means figuratively. It's like a superlative, which oh gosh. All right, we're gonna go a little out of order here. We're gonna go. Tom has been very patient. He's graciously given up his seat for perceived dissent, but he's been on the show before. We're gonna go with Eric in California. Eric, welcome back to the big show.
Hey, how are you?
I'm doing well.
All right. Can you hear me okay? I got you on speaker. I'm traveling right now.
You sound fine.
All right. Awesome. All right. So there's been some discussion, some dispute, a little debate in the chat about certain things. And I just want to call in to clarify a few points. But first, I want to start by saying to everybody out there listening that I have worked with Tom in the past. He has helped me win 2 cases, or maybe 3. I've lost track. So I do use the method. It does work. But there is, what I'm trying to convey in these chat groups is that there are more ways to win these cases than just relying on this method. And you're trying to build appealable errors. And all I'm doing is simply presenting fact in law that you can raise in these court proceedings to later win on appeal. And I'm not sure why everybody is shooting them down or why you're saying that this is not good to go there. You don't have to prove anything. All you have to do is raise it and object to them.
Well, give me an example of something that you would raise that someone on the chat here is disagreeing with you on. Give me one example of a good issue you would raise that.
Well, sure. So out here in California, there are criminal traffic stops. Okay, 99% of them are civil. All right, they are warrantless arrests. Okay, I'm driving in the car if I don't have all the penal code stuff in front of me, but I have researched this. You can challenge the warrantless stop. You can ask the cop, hey, did you have a warrant? No. What was your probable cause? In fact, you should record the stop and ask them these questions at the time of the stop and get them on record.
Ooh.
And that should take care of it right there. I believe it's in California, it's called false imprisonment. And it is in the penal code. And there's three elements, I believe, that you have to prove.
Well,
that's one. Two, a police officer cannot, there's a separation of powers clause in the California Constitution. You can raise that issue as well. He cannot testify and prosecute you at the same time. Thirdly, he doesn't have a bar card. Well, typically they don't if they're cops. You can raise that issue as well. He's practicing law without a bar card. There's three right there.
Oh, okay, well let's take that. Let's go through that one at a time. The separation clause. I don't. I'm gonna have to mute you for the background noise. I don't believe the separation clause stops a. Yeah, I know there's an issue there, but they've never ruled on it as far as can a member of the, because the separation clause is the way, and I brought this up too. I don't use it in court because it's a loser. But as far as the lawyers are all part of the judicial branch, there's no question about it. They are literally officers of the court. They are part of the judicial system. So does the separation of powers clause allow members of one branch to exercise power in another branch, in this case being judicial officers acting as executive officers, such as like prosecutors and attorney generals? The separation clause, I believe, would not allow that. It's not an issue that I've ever seen have any success, so I really wouldn't put a lot of stock in it, because when we go up on appeal, you want to have issues that each issue, and just have a few, that each issue, this is my opinion on it, that each issue that we bring up on appeal should dispose of the entire case and reverse the decision. And something like that, I don't see that happening. Now, there is an issue here where you have the judge, where you have the prosecutor actually testifying. So are there rules that prohibit a prosecutor from actually testifying? There probably are, but here, if the police officer is doing it, I think there probably is a legal exception allowing the police officer to do that. It's the same as when you're talking about the license to practice law. Does the police officer need a license to practice law in order to literally represent a party in a traffic proceeding? And especially when it's a corporation, like you have a body corporate, body politic. It is a fiction, so fictions have to have, only a lawyer can do that. But there in all 50 states, there are legal exceptions to the unauthorized practice of law. So if they deem that the act of prosecuting, such as like when they're doing it in New Hampshire, for example, or California, Arizona, if that's part of the police officer's job, then the prohibition on a non-lawyer acting as a lawyer are inapplicable. So I don't see we can have any success by raising that particular issue. Now, to get to your issue of probable cause, I'm all for attacking that, but I believe that we have a much more effective way of doing that by hitting the source of the probable cause, which the source of the probable cause would be, you would agree, I saw you, the cop is thinking, you're physically in California, Eric, therefore the laws apply and give me jurisdiction to investigate a possible violation of the law. Right? Wouldn't you agree with that?
Well, there's two. You're leaving out the other half of that argument or your position. Yes, that's one. That is the cop's position.
Yeah.
But in order from that probable cause, there must be elements of criminal activity. Either a crime has, you know it all. Crime has to either taken place, about to take place, or you're, fleeing the scene of a crime. But that's the probable cause.
But the probable cause is absolutely linked to the laws apply and you may have violated them. And so I think it's a stronger position to be in. Okay, you've got part one and you've got part two. Part one is that the laws apply. Part two is that you may have violated them. Now, I have evidence that suggests you may have violated this. Now, if you can't prove part one, are is his testimony and facts that you may have violated the law, are those relevant?
So I'm going to stick to one half of this argument and then go to the other. In California, in states where there's civil infractions, the administrative court, you're in front of an administrative, it's not a judge, I think it's an administrator. There is no constitutional rights. There's no.
Well, I got to put you on hold. I got to put you on hold for just a few moments. We're up against the break. So, no constitutional rights. So we want to get right back to where we left off there, tough guy. So hold that thought. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network, and streaming live on my YouTube channel, No State Project. And we'll be back with Eric in California in just a few moments. Don't go away. Welcome back. You're listening to the No State Project here on LRN.FM and the YouTube channel, No State Project. You can listen to either stream anywhere on your phone, so there's no excuse. But whatever you miss here, I will be pulling the live stream down, and we're just going to have an audio-only podcast of the show. It's on markstevens.net, and you can see it and it'll stream on YouTube after the big show. So we'll have the better audio, although the audio from what I see is pretty damn good, even on the live stream. So anyway, let's get back. We were talking to Eric was making a point regarding civil infractions in California, and I think he was saying something about I don't necessarily agree that they're administrative, but bottom line, I don't think whether you call them administrative or constitutional makes a difference. It doesn't make a material difference in what they're doing to you. And I don't think it makes a difference in how to effectively defend against them. However, because bottom line, whether it's called administrative or whether it's constitutional or common law, whatever, the basis of the jurisdiction is always exactly the same. And there's no evidence to show that just because you're physically in California that their laws apply. So anyway, you were saying something about these civil infractions and that there was, again, I couldn't hear because of the feed. You were saying something about no constitution or no constitutional rights?
So yeah, we'll go back to that. I've got an echo here on my end. The administrative courts out here, you've got non-judicial commissioners in these court proceedings. It's a rigged game. Okay? That's why you appeal it and you go on to an actual judge. Whether it's traffic, whether it's, let's say, family law, anytime you're in front of a commissioner, basically it's a free-for-all. Okay? They're not bound by the Constitution. They're not bound by anything.
I got to disagree with you there because I have a written decision. But I have a written decision that I got to look on the old computer to find. I do have a written appellate decision reversing an Orange County traffic proceeding on a due process violation. So it's not true that now they act as if it. I'll give you this. They act as if due process doesn't apply to traffic courts in California or wherever. They do certainly act that way, but the appellate courts have held traffic courts to due process violations and whether what they're doing is fair. So not every time we're going to win on appeal, but there certainly have been examples that I have seen where they have been held to due process violations. So they technically do apply, but in practical sense, well, that's a different story.
So from my research, the administrative courts throughout the country are regulating a certain activity.
Okay.
They're all statutory laws.
Yeah.
And you fall within your jurisdiction, let's just, for the sake of argument, call it that, when you're acting in a certain activity that they regulate. And that's the premise of these administrative courts. Anyways, when you're dealing in other states where these traffic stops are criminal, it's a totally different ballgame because there's a prosecutor, there's an actual judge. You get your trial by jury. You can have your bench trial. You can have your public defender. It's a completely different ballgame.
Well, you can have, but it depends on where you are. If you're in Detroit or Michigan, rather, in some other places like Florida, for traffic, yes, you can get a jury. but it's not universal. And where in most places in the United States, DUIs are criminal. It certainly is in Arizona.
Correct.
It's not criminal anymore in New Jersey. So in New Jersey, you're not getting a jury trial for a DUI. So it depends on where you are. The jury trial isn't always, and you could be in New Hampshire on a traffic. It doesn't mean you're going to get a lawyer, bar member type a prosecutor. They have police prosecutors. Jean Killam, for example, is out of Keene, New Hampshire, and I've been involved with cases she was prosecuting, or complaints rather, and she's not a lawyer. You know, they have police who actually prosecute these lower level infractions, whether they're civil or criminal. So it just depends on where you are. California happens to be a place where, or like Arizona, where depending on the severity of the infraction, whether there's going to be a formal prosecutor or not. And I don't know if it's accurate to say that these hearing officers in court are considered non-judicial. That was something that was also brought up about the judges of the tax court, whether they are, they are federal judges, because they're not in the judicial branch. They are part of the legislative branch. So, yeah. But here, do you have any actual citations, any proof to show that a commissioner hearing a traffic court in California is not a judicial officer?
I will find you some. I don't have it on hand in my car, but I'll find you some.
Okay, but you're aware, but you do have a citation that would show that commissioners are non-judicial.
Well, they don't have a sworn oath of office.
If they don't have a sworn oath of office, then they're not even administrative officers. So technically, without an oath of office, they're not government employees.
Out here, you can hire anyone basically to do the administrative, judicial aspect of it. One of these traffic cases. That's what I'm trying to tell you. I've had family go through the family courts with commissioners who they are attorneys, but they are not sworn in judges. And they've had their cases reversed by not ever giving authority of jurisdiction to the court.
I would like to see some documentation to prove that, because
it's actually case law out here in California.
Now, I have had on occasion, and I've done this myself personally here in Arizona, and they don't really like us doing this for obvious reasons. And I had a friend do this and get the same result. I got something tossed out and helped someone else get tossed out because Noreen Richardson was a prosecutor. And I've dealt with her before. She is one of the nastiest people in the Mesa court. I don't even know if she's still there. She did not have an oath of office as a hearing officer. And I went to court, and someone else did this the same day. Right in front of about 50 people, he did this. And he said, "You are not a judge. You are not." And she says, "That's true. I'm a hearing officer." No. You are not even a hearing officer. You are a prosecutor. This is the most current oath of office you have. You are a prosecutor. And in the embarrassment, she wound up tossing out the ticket. I would like to think that there was a mutiny there. People say, "Hey, what?" So I have had experience with that, and I'd like to be able, but that's a little different than what you're saying. I would like to see the documentation that you're talking about to show that that's true. Because if that's true, I would certainly add that to the arsenal.
Okay. I mean, that's something that you would go into your initial pretrial, whatever, and ask the judge that when you're doing these questions, which the method doesn't entail, but that is something that I've incorporated into my script.
Well, we used to get into the whole thing about, am I entitled to a fair trial? And, that kind of takes a back seat to really striking at the root, because we typically don't have the time to get into something. It depends on it depends on the nature of the judge, because I would say 9 times out of 10, we're not going to have the luxury of time to get into those issues. We have to go and we have to hit the foundation of the prosecution's case right off the bat.
I agree with you. But I think you could also bring up some other things throughout in that initial setting, some of the other questions that you've got on your script, and you can also bring up some of the constitutional guarantees and protections that you have.
Okay,
at least in states like California where there's civil infraction, and you're not given a trial by jury out here. You're not given a public defender because they want to tell you it's criminal, but it's actually civil. And these are just issues that you can raise and then try to appeal on later. It's just more ammo for you to fire at them.
So the thing is, with a civil infraction in California, historically you're not entitled to a jury. Even with a lot of misdemeanors, unless there's jail time attached, they don't give you a jury trial.
Yes, I agree.
So I don't see that that's
nowhere.
But I don't see how that's an issue that I would want to take up on appeal. So give me an example of an issue that if you take it up on appeal, that issue and only that issue alone would require a reversal of the judgment against you. So give me another example where that would be the case, where it meets that standard. In fact, we're up against the break, so just hold on. We'll finish in the next segment about it. So I want an example of an appealable issue where that issue would reverse all by itself. My name is Marc Stevens, talking with Eric in California. Man, I haven't mentioned Noreen Richardson in a long time. I'll have to look up and see if she's still a judge there. Just a nasty, nasty woman. Screams, yells. She's either calm or she's not. She doesn't have anything in between. She's either a nice woman or she's screaming, and it's just terrible, terrible example of. Anyway, we'll be back here on the No State Project in just a moment. We're going to be on the breaks on the LRN stream, so don't go away. We'll be right back with Eric. Yes, welcome back to the No State Project. Third of 3 hours of Anarchy Radio right here on the Liberty Radio Network. And anarchy meaning no rule is not no rules, from the ancient, from the literal translation of the Greek anarchy. Archons, which is ruler. And we'll get back to Eric in California. So someone had brought up asking about, we're talking about societies without government. And I think Tom thought mentioned, there is medieval Ireland. But the more recent one actually survived for over 400 years. Now almost 400 years. Now, granted, the Republic of Caspia, in Italy, northern Italy, Umbria, from 1440 to 1826 is admittedly very, very tiny. I like the flag, though. They're saying the flag is the black and white, which is really cool. It's described as a micro-state. Very, very tiny, but they survived without government at a time when the popes were very powerful still, for 400, almost 400 years. So again, that's why people will make fun when we say, well, give us a historical example of a society without government. Well, and then you mention that, well, that was so tiny. Well, that's what she said. It's still an example. It's like advocating for not against spousal abuse. Well, show me a society where there isn't spousal abuse. Show me where it's actually been successful. Show me. I can't. That doesn't mean it's a bad idea. It doesn't mean. Gee. Okay, so we'll get back to Eric in California. So Eric, I was asking you for an appealable error that on its own would reverse the trial court decision.
Okay, I missed everything you just said in the intro there. The connection's cutting out.
Okay.
But as far as appealable errors go, things you can raise, it's not.
Well, an appeal. Wait. It's an appealable error that, like a denial of cross-examination, warrants the reversal of the decision. It's got to be that strong.
Sure. Let's just start with the warrantless arrest, the false imprisonment. Let's go with that one. But it's not. You don't build your case on one single appealable error. You got to throw all you can at this. You want to make sure you come out the victor.
Well, I think I'm for putting appealable errors in, but I think that we're best served by the errors that we raise. Each one on their own are so strong that it disposes of the case. And one of the reasons why is courts historically want to shy away from very, very tough questions. Okay, that's why some issues are not heard by the Supreme Court, because it's just it's just not a topic they want to visit. And I think when they have a case where there is a very clear-cut issue, they can avoid. So let's say you've got 15 solid issues, but some of them are really difficult politically. Okay, they're hot-button issues. So what they'll do is they'll focus on one that disposes of all the other issues. So they'll say, and they'll actually rule this way. We don't have to visit the question or discuss the question of XYZ because we can dispose of the case on this. There was a Brady violation. It was unfair. The defendant was denied a fair trial. We're reversing, and that's it. Or you have a denial of cross-examination, and we don't have to visit that. So I'm not saying that we're not going to necessarily raise more than one issue. I just think that the issues that we do raise should be as strong as that. So another one would be a denial of a voir dire if, in fact, you did have a jury, which is an automatic reversal.
Yeah, the voir dire would be later on, though. Well, that wouldn't even apply to traffic cases out here in California.
Right.
You wouldn't even have...
Right, exactly. But I'm just using that as an example where it's an error that is so bad, it warrants the reversal of the decision. So,
yeah.
So you're saying it false. You have to actually have facts that would satisfy an appellate court, and then hopefully you can get that through in your cross-examination and use the prosecutor and the cop's statements against them. But have you ever seen where an appellate court reversed because they considered the traffic stop to be a false imprisonment?
So you set up the judge, get him to speak on this matter. You ask him if this is criminal or civil. Instead of civil, say, okay, well, where was the arrest? Because hopefully at the traffic stop, you recorded the conversation with the police officer. You asked him, what's your probable cause for the stop? You can ask him at the time of the stop as well, is this an alleged crime or is this a civil infraction? You got the cop on record, you got the judge, the commissioner on record out here. Then you can ask him, where's your warrant? I don't have a warrant. Okay, and you didn't have probable cause. Now we're in a little sticky issue.
I think he's just going to say...
Now you got false imprisonment.
Well, I don't think it's necessarily false imprisonment because he can just say he's investigating. His probable cause is that, let's say, it was an illegal lane change. And that...
But that's a civil infraction out here.
Yeah, but it's caused to stop you. But it is caused to stop you. They're not pulling you over arbitrarily. Now, if he's going to wait. If he's going to search the vehicle, now he needs probable cause. Again, that's why they want the window lowered so that they can pretend that they smell pot. That gives them probable cause that there's contraband in the car. So they've never ruled against, as long as the cop has some articulable suspicion that the law is being violated for traffic, like a traffic law, then they can stop you. But from there, so I don't think on just a straightforward no driver's license or a taillight out, you're going to be able to get them for false imprisonment.
Well, if there's no elements to an activity, civil, there's no criminal elements, the cop can't stop you. There's the famous case out of Ohio with Terry. There has to be some element of a crime in order for a cop to detain you.
Or he's got probable cause to determine that the laws are being violated because they're enforcing the traffic code. And I think you're mixing the two up.
You're taking your position with your method and you're applying that to Terry versus Ohio. And they're two separate things.
Terry has never been, as far as I know, Terry has never been used to strike down the police from doing civil traffic stops, just because they're called civil.
I don't know who's ever challenged it, but you're taking the Socratic method, which can apply to everything across the board. And you're taking that and trying to apply that to whether they have reasonable suspicion or probable cause, which has to have criminal elements. And those only apply to crimes, not civil.
Yes, but they have always been ruled to have authority to investigate traffic stops, whether it's civil or criminal. And that's why it goes. I asked if there are any cases, state or federal, that have ruled that Terry versus Ohio, the need for probable cause and reasonable articulable suspicion negates them from stopping you to investigate a civil traffic violation. That doesn't mean that, look, there are cases where I can show you Brown versus Texas, and it says you can't arrest somebody simply to ascertain their identity because it violates the Fourth Amendment. And that was a 9-0 decision, but it was a unanimous decision by the Supreme Court. They violate that every single day. I'm not saying that, but I've never seen where a court has a Supreme Court has ruled Terry versus Ohio only allows them to stop you if they're alleging a crime has been committed. They cannot stop you for a civil traffic offense. I haven't seen that. Eric, I do appreciate the call. I wish I had more time, but I don't. I've got a full line of calls, and I'm going to try to get through as many as I can. But call the show again, and we can explore this further. And I would like to see the evidence that we talked about earlier about the judges not being judicial officers. My name is Marc Stevens. We're going to get to Tom in the Big D after this short break on LRN.FM. We'll be back in just a moment, so don't go away. I have to unmute for you to hear me. So welcome back to the No State Project. We're going to get right back into it. Got a full boat of calls. Going to do my best to get to everybody. I'm going to predict we're not going to, but we got Tom from the Big D back on the show. Tom, welcome back.
Hey, Mark. Been a great show, and the time has gone by fast.
Yeah.
The lady that called in, I forget her name right now. I mean, when you listen to a story like that, oh my God, she must have pissed in somebody's Cheerios to get that much. It's just unbelievable when you hear stuff like that.
Yeah, something happened, and maybe it's because she was unfortunately doing some Sovereign Freeman type stuff that just set them off. That's why I can't stress enough not to pull that crap. We should only be challenging the assertions that they're actually making, not making assertions of our own, because that takes a burden on us. It should be just a relentless attack on the prosecution's claims, because that has shown itself to be sufficient. Look, our job is to punch a hole in their case, and that's very easy to do.
Yep, and not go into the merits of anything of the case. And as Eric, has been typing in the chat here, all these suggestions, when you start to challenge them on the law, you will lose, period.
Yeah, absolutely. If you're going by legal interpretation, what the laws mean, such as whether you're a taxpayer within meaning of statute, whether you're an operator within meaning of statute, stuff like that, you're going to lose. You're absolutely right. And the reason is they have contradictory interpretations from their courts that they can use against you, and they're being responsive. Oh, and to try to get that overturned on appeal? Come on. Come on.
And the bottom line is, if they did follow the rules are quite simple. There has to be damage, injury, palpable, as they actually say, palpable damage, injury, or a violation of someone's rights, as kidnapping. I mean, it's that simple. There is no crime unless those three elements are in it. The rest is just opinion. They're just controlling rules. That's it. You're never going to win on that.
Yeah. People think of, calling something a crime is magical. It's literally whatever the legislature, says is a crime. And that's not how an adversary system works. The adversary system, the limits are set by their sacred law. And that has to be an actual antagonistic assertion of rights. And that's what the Supreme Court has always held. It's an adversarial system. They can't just make being Irish a crime like they try, like the England, Cromwell, right? It's not you cannot. I even have in the motion to dismiss that legislative enactments can't enlarge the jurisdiction of the adversary system. That's what they, the Supreme Court is. So you're right. There has to be, in a crime, there is the legal injury that's alleged is that you violated the law. The laws apply and you violate. That's the legal injury. And there's not a shred of evidence to support that claim. Not even for a prima facie level at the beginning.
Yeah, that's always their little, as our friend Misty always says, that's their little out. Anything they claim is prima facie. It doesn't work that way when you and I try to sue a judge or a cop or a prosecutor or anything.
Nope.
No, that doesn't count.
Nope.
It's quite evident, but nope, that doesn't work that way.
And
speaking of that,
real quick, hold that thought. And that's the thing. If people like that were correct, then we would be afforded the exact same burden, right? You're dead on. It's just like when they say that the prosecutor doesn't have to prove a legal claim, and yet they don't allow us to do that. Why? Because it's wrong, and they know it's wrong. But that goes to their system. It goes to how they're able to prosecute you. So of course they're going to use a double standard. And I've already shown they can't meet a prima facie burden. There's no possible way that my physical location in Arizona actually has any chance of proving a written instrument from 1910 applies to me and creates obligations. There's zero chance. So they don't make it's just real quick. I'm sorry. I'll blow through a commercial to cover this. It's just like when the IRS claims to have a presumption of correctness. It doesn't arise because they say that you owe taxes. It only arises under their rules if it's reasonable and rational. And making an assumption is not reasonable or rational, so they can never have a legitimate presumption of correctness. And there's no way that they're going to allow us to just say something is correct and have it be presumptively correct. We don't get that presumption. So
isn't that interesting? Isn't that convenient?
Well, and so I don't even want to hear the excuses. I'm not going to go out of my way to hear what the excuse is for someone like that when she says that they can get away with it, but we can't. You do look legally and logically, you do not get a presumption of correctness just because you say so. You have to have a reasonable and rational basis that is supported by some facts if we assume that they're true. I'll give you that. That's the standard. But even if you do assume it's true, it doesn't prove that. And we know I've even asked Scott Bales with the Supreme Court of Arizona, and he could only say, well, we put other people in prison. Putting other people in prison doesn't prove the proposition. Anyway.
Yep. Are we on break? I mean, I can continue talking.
No, keep going. We're not again on break yet, but I'll blow through it.
Okay. Well, one of the things that you were talking about, or that came up earlier, of this civil infraction and the argument of it being civil or criminal, it's really interesting. Even when they agree it's civil here in my state on certain tickets that I've had, when you start bringing out the elements and the rules in a civil case, then no, you're misunderstanding. It's not that kind of civil case.
Yeah, you go in and you want to apply the principle of standing, which at the federal level is a jurisdictional issue. Now, not every state is it a jurisdictional issue. It is a bar if you don't have standing, but they don't necessarily consider a jurisdictional issue across the board. But it is a bar to suit. And I know they want to say none of that doesn't apply here. This is an adversary proceeding, and this is the way I do it. You ask them, objection, isn't this an adversary proceeding? Yes or no? Oh, it is. Then how could
let me tell you something.
How can that not apply?
This judge that I've had here, this woman, Catherine Steenland, who also one of our other guys had, Norman, who she railroaded as well. The bottom line is, I asked that question, and there was a whole courtroom full of people, and there were lawyers, and I asked that, and she bluntly said, no, this is not an adversarial system. I have this in a transcript.
Well, we've seen that before. I'm sorry, but we had that happen in California, for example, with Samson and Delilah. It's shameless. And what do the critics say when we have judges that you've personally seen and have a transcript of where the judge comes right out and says it is not an adversarial proceeding? What do the critics have to say? Will they dare, like a Trump supporter, would they dare say that the judge is wrong? Have you heard any of this handful of critics that are so consistent?
I don't know if you can hear me.
I can.
Okay. You were cutting out really bad. I'm hoping that everything you're saying is going to be recorded later. But
yeah,
go ahead. I just wanted to let you know that I don't want to sound like I'm retarded here. I just can't hear you.
Too late. No. Well, I was just saying that I've never heard any of the critics give an excuse as to why judges such as the one you've seen will say that it is not an adversarial proceeding.
Yep. Well, she said it, and this was in front of the other lawyers. And as I was battling her on it, I kind of turned my head a little bit. I like to watch, and they're chuckling because they knew I had it by the short hairs, but she didn't care. They don't. They follow the rules if they want to, and she knew at that point that I was not going to be able to appeal her. She was the chief judge, and for me to do it, we went through this blah blah blah. I now know how to do it, and I now know which forms to file and yada yada. That will never happen again. But she bet on it, and she won. So. Anyway,
what is that?
If we've got time, I'd like to touch on another topic.
Yeah, but before we get into that, what does that tell you when an appellate court affirms the decision that it's not an adversarial process or an adversarial system?
Well, the appellate court did. Okay, here's the deal. In this, the way it works here in Michigan, you're cutting out really bad.
Just keep going. I can hear you.
Oh, okay. All right, well, here in Michigan, in a traffic situation in most of these cities, you first appear in front of a magistrate, so that's the first rung that they try to get you to quit. Then you can appeal that. That's really simple. You just put the bond up and you get to see a real judge, and hopefully you don't see another judge first, and maybe he will or she will dismiss it, and then you can appeal that, and you can get to the chief judge. Well, once you hit that judge, which was her, Catherine Steenland, she knew that for me now to appeal to the next level, that would be circuit court. And there's a whole bunch of hoops. We've discussed this before, the transcript, the whole 9 yards, has to be special, and special forms, and blah, blah, blah. And she bet that I wouldn't do it, and she was right, because I didn't know how. So I didn't formally appeal to that next level up. I failed. That was my own fault.
I like to think that if you didn't fail, something would have been done. You would think that, when they make statements like that, or when they say things like there's no right of cross-examination in traffic, which has been said, you would think that a higher court would look at that and say, are you out of your mind? Wait, you're putting us in a position, we have to ignore the issue. The only thing they can do, because if they address the issue, they have to try to spin it somehow to say, well, you really don't have a right to cross-examine a witness in traffic. And they won't have any sources on that. Right. It happens. When I think one of the things we should do, and I've mentioned this before, when they say something like that, object and say, I need you to be very, very clear, because I think the appellate panel is going to have a stroke reading what you just said. So very clearly, so that I'm able to, appeal this and I can adequately defend myself. Can you say very clearly on the record this is not an adversarial system and that the Michigan court system is not adversarial? Just say that, because I don't think the appellate panel is going to believe me.
Right. Well, she said it. I mean, even without me going into that detailed of a question, she blatantly said it. I have it in the transcript.
Sure.
And I wish now, obviously, in hindsight, that I would have pursued that. But yes, she literally said that. This is not, and because my next response was, what's the other option to an adversarial court? Like they have in Iran and, other places where you're presumed guilty, first, and you have to then, prove yourself innocent.
That's inquisitorial.
Think of it.
Inquisitorial.
Yeah, that's it. That's what I asked her. I said, well, if I'm not in an adversarial court, am I in an inquisitorial court? No. Okay. How does this work then? I mean,
Wow.
she just, she does, it's just like a Dick Noble, where Terry and Noel are at up there a little bit further up Michigan. They don't care.
No.
The worst, I think the scariest judges truly are the rural judges who have no desire to be anything more, and they just roughshod over everyone, and they don't care. They don't even care if you win the appeal. They don't care.
No, they don't. Look, they don't have to give a damn. They're not going to lose their job, and this is why I always advocate, and hopefully we got more people that are going to take them to task. Put your facts together about what they're doing. You take the admissions. Damn it, you have a transcript, and you take it to the county risk management. And if it's turned down, you can go right in. You could take it into court. And
well, hold on now. Hey, I called my city manager here because, I called the city and as it went up the line, I ended up with the city manager. What I was trying to find out is who covers the city. Who is the city's risk management, insurance, bonding agent, whatever. And his question to me was, after I asked that, he says, why do you want to know? I says, well, I want to know. It's something I want to pursue, blah, blah, blah. He says, well, unless you tell me why you want to know, I'm not going to give you that information. I swear to God, I couldn't believe it.
Well, cops do that too. If you want to do a complaint, they have to tell you, they want you to give them the information, and then, of course, they'll threaten to arrest you. Well, most of the information should be available online. If anything, I think the best way to do it, and this is the way I do it, call the city or the county clerk, and they should be able to give you that information. If you talk to somebody that's higher up, oh, you did? I'm sorry.
Mark, that's who I called. And as they pushed me up the line, that's where I ended up with the city manager.
I'm sorry.
Because nobody wanted to give me that information.
Well, I guess if they're going to not give you that information, you could just file your claim with the city clerk or the county clerk with instructions to get this to the appropriate agency that handles these claims. And maybe what you can do is also file a copy with the county commissioners and say, this needs to be processed appropriately. And and so if it's not, that's going to be used against the county as bad faith in trying to block my claim when I file in court.
Well, check this out. Here's a real kicker. I got a letter the other day from the city. It's like addressed to the residents. I opened it and it looked like it was from an attorney. And check this out. It's a lawsuit. What do they call it when there's a group of people in it? Well, it doesn't matter. It's a lawsuit somebody is making against this city, the Corporation of St. Clair Shores, Michigan, the municipality Corporation of St. Clair Shores, Michigan, suing them for something to do with the water department. And it's like a motion, and I haven't read through it all. I am going to check this out. So somebody is suing this municipality, and nice. I want to learn from this. I'm going to be a part of it. I'm going to pursue it and try to get as much information from it as I can to understand how to go about doing it.
Well, again, you could. If they're going to deny it by not processing it, then I don't think that bars us from bringing it into court. So, because to get to court, they have to turn down the claim. Well, if they're not going to process it, add that to the claim and file in court. You've given them the notice. You did what you were supposed to do. They said, "Abba fungal," and it opens the door to court. Which, once we get to court, you can then initiate the discovery process after they're served. Get that damn judge who made that statement into a deposition and give him a copy of that transcript. Didn't you say this? Did you know? And you see, the thing is, as a lawyer, she doesn't have a legal right or standing to argue ignorance. So for a sitting judge, they cannot argue that they didn't know it was an adversarial system. They don't get to argue that.
Well, hold on. Mark, check this out. Not only did she say that to me, when I asked her something in there, it's just been a while. It's not off the top of my head. But I remember asking her or stating or something about her being a lawyer, and her response, this is on the transcript as well, I am not a lawyer.
Okay, fine. She's still a sitting judge. I don't think anybody
exactly.
sitting as a judge gets to argue that they have any standing to argue. I didn't know that it wasn't adversarial. You gave her the information.
Right.
It's
right
in the motion to dismiss that the United States court systems, whether it's state or federal, are adversarial systems. We do not have an inquisitorial system and haven't had an inquisitorial system, at least in the Anglo tradition, since the Middle Ages. Well,
right.
I guess
Yep.
if you're in Spain, you could, I guess it could be argued that they had an inquisitorial, the whole Spanish, nobody expects the Spanish Inquisition, but we're not talking about Spain. So, if they're going to deny it by not processing it, fine. You say Abba Fangul and you take it to court and serve them. Again, we're going to wait until after we do a deposition on the judge or prosecutor, if there is one, and then join them by using their own statements against them, because the judge will not be able to. Look, do you think that the judge in a deposition would be any more capable of proving the laws apply as when I speak to them outside of a deposition, like at the ASU Law School? Do you think they're any more capable? No. And if that judge cannot produce the evidence to prove that there was jurisdiction, then they never had jurisdiction to begin with. They knew they didn't have jurisdiction because you filed the motion. And because they never had jurisdiction, then technically they can be joined as a party and be made responsible. Doesn't mean it's going to happen. I want to be able to, and I'm hoping some of the people I'm working with will get to that point where they can get at least the judge into a deposition. And even if all we get out of it, Tom, was the opportunity to make the deposition available publicly so that people could see that these judges know they have no evidence. They know the prosecution hasn't met their prima facie burden, and they don't care, and they prosecute us anyway. And the appellate courts are just as culpable because they allow it to happen, and they allow that to be affirmed on appeal.
Well, they're all in cahoots.
They certainly are on the same team.
Right now here on Michigan, the vote came in that marijuana is now recreationally legal, and
cool.
Yet I'm reading in my local paper here, St. Clair Shores, that nope, they're going to opt out, and I am dying to go down there. My record is, I have a target on my back, and I need to avoid confrontation with these clowns. They've already surrounded my house 3 times. You're aware of that, and I can't believe I'm still above ground after that. I have to give the cops here in St. Clair Shores kudos for restraint. But anyway, I am so tempted to go down there and say, now wait a second. The people voted for this. Let's play their game. The people voted for this, and yet you're going to tell us that no, you're going to make up separate rules? How does that work?
I don't know how they're trying to do that, but I'm gonna. We are on a break on the LRN stream, so I'm gonna see what I can do about getting at least one more call in. I'm gonna try to get 2 more calls.
Okay.
In. But hey, I appreciate
I wanted
that.
I wanted to get to the borders thing, and we didn't get there. We'll do it Saturday, or today is Saturday. We'll do it Wednesday.
We'll do it Wednesday. We'll do it live.
All right, brother.
All right, take it easy.
Have a good night, my friend.
Thanks. Appreciate the call. Let's see. I'm trying. Let me get another call here. I'm hoping it's who I think it is. Well, we're going to take a shot. Area code 808. You're live on the No State Project. What's your name? Where are you calling from?
Hey, Mark. This is Rourke from Hawaii.
Hey, I got it right. Why did I think that was LA? That's 818. 808 is okay. So, all right. What do you got for us today?
Okay, so basically, I'm just calling about a ticket that I got. I drive Lyft and Uber. So I picked somebody up at the airport, and supposedly it was, in the Lyft a map. It says it was in the right zone, but the officer who was, I guess hired privately or something, I'm not sure how that works, but said that I was doing business in an unauthorized area and wrote me a citation. So I had to, go to court and everything. And, I've already been 4 different times for, an arraignment to enter a plea. So it started at district court, and then I guess they, assigned me a public defender and then demanded a jury trial. So then I went to circuit court, and this was just on Thursday.
Oh man.
So, I went with a bunch of questions and everything. And, supposedly the, public defender's office said that there was going to be nobody there to defend me. And I was like, okay, well, all right. I came prepared. And then next thing you know, there's a public defender there defending me. And I was like, well, I've got some questions here to ask the judge first and this and that. And, I got halfway through my questions and they stopped me and basically, finished the, hearing, gave me another court appearance in front of a jury. And then the public defender talked to me outside and said, well, we're going to, try to put in a motion to bring it back down to district court. So I don't really know what the deal is there.
Well, have you filed a motion to dismiss and Brady request?
Well, I tried to, but they said that the attorney representing me or, public defender is the one that has to do that. So. Okay,
that sucks. And they're not willing to file it?
Well, this will be my 5th time going, and, I've told them every time, I need to, file a motion to dismiss, Brady material and all that sort of stuff. And, yeah, so.
Okay, but the public defender is not willing to file the motion to dismiss. Are they willing to at least go standby so that you can both file paperwork and make objections and raise arguments?
I haven't asked them that.
Well, if you want to be able to defend yourself, you're going to, that's what needs to be done. So this way you can defend yourself with assistance of counsel. So they're there as standby, of course, to help with objections. Okay. They can make objections. They can counsel you, and and then you'll be able to file your own paperwork. So there's not much we can do right now, until you're able to defend yourself. So again, I'm not advising that you just get rid of the attorney, period, especially if this is your first rodeo. But at least see if they're willing to be standby and that the judge will allow that, so you can both defend you.
Okay, cool. I'll go about that then.
Let me know. Find out. Call them on Monday and see what's going on, and let me know on the Wednesday show, or at least email me and let me know what's going on.
Mm-hmm. Cool. Sounds good. I appreciate that.
Not a problem. Appreciate the call. Looking forward to some good news on Wednesday. All right?
All right. Thanks, Mark.
All right. You're welcome. That's Rourke in Hawaii. We're going to go to, we're going to do our best to get other calls in here. We have Shane in New York. Shane, welcome back to the show. You've been very, very patient.
Yeah, hey, Mark, how you doing?
I'm doing well. I don't have much time, Shane, so you got good news for me.
I just wanted to just chime in really quick. I want to let you know I did file my claim and signature request green cards to the town and my traffic case where I was locked up for 9 hours. I do want to let you know I did send it out about 2 weeks ago, and I haven't heard a thing. I was just wondering if you knew something very quick. How long do you have to wait before you can file a suit?
I am going to just throw the estimation out based on some other ones that I've seen. You're going to have to wait at least 6 months. So I think that I think they have 6 months to act on it. Again, you check the local, and so know for sure before you then file into court.
Okay, I'll write that down. I'll wait 6 months. And that 6 months would start from the day that they received it, right?
Yeah.
Okay, that's all I need. Thanks a lot, Mark. A great show today.
you are dedicated. you.
No, this is, hey, listen, Mark, this is how you learn. You got to listen in.
Well, that's great, but you don't have to be on the phone to listen. But I guess there's a phone listen line for LRN. So, but yeah, okay. Well, that's great. I'm glad that you're listening in, and so hopefully you hear back before the 6 months, though. Either way.
I will. I'll keep you up to date. Thanks for everything, Mark.
I appreciate the call. It's Shane in New York. We got another call here. You're anonymous, but you've been almost as patient as Shane in New York. So I think you're using Skype to call. What's your name? Where you calling from?
Yeah, this is Tom from Missouri.
Tom from Missouri. Oh my gosh! See, you are not the kind of call I can take in the last 9 minutes of the show.
That's all right. It was a good show, like you said. But we got your kicked out ticket up here, so that really looks nice. I was glad to see that.
Yeah. You. Which? So, I posted
your latest one that you posted. Yeah.
Okay. I forget, where was that?
Yeah, that was really nice to see that. I was really glad to see that come here to this area. Do you have more than one kicked out in the same place? Do you have anything like that?
What, you mean the same court or the same city or?
The same state. The same state.
Well, we have two that I'm very proud of. Two kicked out in Wales, which was pretty nice. I'm pretty certain. I can't give. We've had a lot of stuff thrown out in Southern California.
Okay. I was just wondering. And can you tell by the how many views it's gotten? Is that one? I haven't really looked at all of them that you get, but it's got pretty many views already just for the little bit of time that it was up here.
Well, that's thanks to all the new subs that came over from Brian at High Impact Vlog, which I do appreciate. That's why the numbers the last week, couple of weeks have gone up. It used to be I would post a video of a success. There was one I think I had 4 tickets thrown out that I posted in that video, and like 400 people. It was like 400 views. I'm like, really? And then once Brian started getting involved in helping out that way and doing some videos with my call Shane's.
Do you see something like a snowball getting ready to happen here?
I wish that were true. I don't see that. I don't think 1,500 views is a snowball. If it was 15,000.
Well, no, I mean, all together, everything put together. I mean, it's looking like what you're doing is going to snowball one day. It looks like that.
I'd like to see that. But still, for right now, Brian can take the exact same content, like my call of shame.
Yeah, that's a good answer. Hey, yeah. Mark, didn't you say that you had an FBI number, that they had given you an FBI number?
An FBI? An FBI? What? Like a direct phone number?
No. That you had gotten in trouble or something, and they gave you an FBI number?
I've never said that.
Okay. And I thought that you said that you sent a FOIA request to them, and you got that all straightened out and had them erase it because they had made a mistake, and you corrected it.
That's not me.
I didn't hear that right.
No, that's not me.
Huh. Okay, well, I'll look that up. I mean, I listened to all your stuff, and I thought for sure. But also, I watched a YouTube on gaff trap that some guy's talking about you.
Oh, what?
Did you see that? It's GAFT, gaff trap. Mark Stevens doesn't know what he's talking about.
There's a persistent critic who's been on the show, and he does, from what people tell me, he does a video based on every show practically. And I look, I've already.
Yeah, and if you
know
the stuff, he's pretty much full of it. But anyway,
I'm not interested.
I need some stuff from you, and this is the only way that I can get a hold of you. Is there some other way? I need a motion, a FOIA, a Brady, and a discovery. Is there any way I can get in touch with you?
Yeah, email me, markstevens@mail.com.
I can't do that. I can't do that, Mark. This is the only way that I can do it right here. Somehow I have to reach you, and the only thing I can do is by the phone.
Well, if the only way is by phone, I won't be able to send you the documents.
Okay, and why is that?
because I'd have to print them out and mail them to you, and that's just not. You don't have an email that you can use?
No,
I'm running out of time here, and there was something else I wanted to cover. So let me put you on hold so that we can talk about this off the air, okay?
Okay.
All right,
Okay.
So
Okay.
I'll
Good.
mute you up there. So I wanted to, for James, he asked me to discuss the as-applied challenge as opposed to a facial challenge when you're talking about constitutionality of a statute. So it's right, you can get it on the Rational Wiki, and I'm going to put the link in there, James, for what I'm talking about. Because the facial challenge, of course, is a statute unconstitutional as it's written? Saying, so let's say, for example, if the statute is vague, so as it's written, that would be a facial challenge in that it's written too vague, as opposed to an as-applied challenge. It would be that they are applying a statute in a manner it wasn't meant to be. So when challenging the constitutionality of a law, the normal method of seeking invalidation is a facial challenge, which invalidates the law itself, okay, as having no constitutional application whatsoever. Most Supreme Court cases are resolved in this manner. However, sometimes a facial challenge is untenable or difficult to argue. The easier method is to win often will be as an as-applied challenge, seeking a declaration that the selected law is invalid as applied to your client based on a particular facts of the scenario. The best example of a facial versus as-applied challenge in recent memory is the case of National Endowment of the Arts versus Finley. In this case, the federal government, acting as patron of the arts through the NEA, promulgated guidelines for NEA grants that granted the NEA the power to evaluate work subjectively before funding them on the basis of the offensiveness of the work in question. Content-specific criteria like these are generally invalid when they function as a restraint on free speech. Normally, the interest of the speaker trumps the interest of the government in restraint. However, the Finley case posed a problem of competing interest. After all, the NEA funding is limited, so the government ought to have the ability to make subjective decisions, especially given the subject matter of the art. Therefore, Finley Court held that while the NEA's subjective judgment criteria were not facially unconstitutional, that is, they could be applied in a constitutional manner in line with legitimate government concerns, they could be unconstitutional as applied. For example, where a denial of an NEA grant occurred merely because the art in question would have depicted homosexuality. I got nothing against that. I prefer my frogs gay. The NEA criteria would presumably be unconstitutional. The idea is that if a statute is legitimate most of the time, it generally shouldn't be struck down, even though it has unconstitutional outcomes at the extreme. So I hope that helps there. And we're pretty much out of just as the bumper came in. What perfect timing with that. That was good. My name's Marc Stevens, of course. You've been listening to the No State Project for the last 3 hours on LRN.FM, the Liberty Radio Network, and streaming live on my YouTube channel, No State Project. I will have this up after the show, so it's commercial free and it'll be available on my YouTube channel. So until next time, salud.